I'd like to thank you all for coming and welcome you to the National Press Club. On behalf of the Law School of Catholic University of America and my law firm, Silverman Thompson, Slutkin and White. And I'd like to really, before I start, say a special thanks to CUA Law, in particular Dean George Garvey, my colleague and former professor Clifford Fishman, and special thanks to Tom Hederle, who is the Director of Public Affairs, and whose interest in the subject and enthusiasm really made this panel possible. I also want to thank my law partners, the Honorable Joseph Murphy to my right here, and Steve Silverman, who's with us today in the crowd. Steve is the firm's managing partner, and they've really put their resources behind this, and we hope we've put together a good panel. So I want to briefly introduce the panelists, but please take note that the time is really short, so I can't give them the full credit they're due. These brief introductions don't really reflect the caliber of the folks we have here. So the Honorable Judge Murphy is retired from the Maryland Court of Appeals in 2011. He now heads the alternative dispute resolution practice of Silverman Thompson. Before his 1984 appointment to the Circuit Court for Baltimore County, Judge Murphy practiced law as a legal aid staff attorney. He was an assistant state's attorney in Baltimore City, then the deputy state's attorney for Baltimore City, and a partner in the Towson-based law firm of White and Murphy. He was appointed to the Court of Special Appeals in 1993 and became its chief judge 3 years later, a position he retained until his 2007 appointment to the Court of Appeals. He is the author of the Maryland Evidence Handbook. He teaches evidence at the University of Baltimore Law School, and he teaches trial practice at the University of Maryland Law School. We're also honored to be joined today by Janet Fisher, who is the General Counsel for the House Permanent Select Committee on Intelligence. Janet has an amazing background. She's a former Williams and Connolly attorney. She's a former Justice Department attorney. She was a judicial law clerk to the Honorable Richard Roberts with the U.S. District Court for the District of Columbia. She has a B.S. in Industrial and Labor Relations from Cornell, and she received her J.D. from Harvard. We also have Professor Clifford Fishman, who's my co-author of Jones on Evidence and Wiretapping and Eavesdropping. Cliff is a former prosecutor from New York City and has taught for many, many years at Catholic University. He's an author of numerous scholarly articles, and we're very honored today. He's one of the most renowned scholars in the field of electronic surveillance law. We also have Canon Shanmugam, who is a partner at Williams and Connolly and has, as a very young and prominent lawyer, argued before the Supreme Court more than most people will ever do in their lifetime. And he really brings great insight that will help us today as we go through what the Supreme Court might do with these issues we're going to be considering today. Canon, like Janet Fisher, is a graduate of Harvard Law School. He's also a graduate of Harvard undergrad, where he graduated summa cum laude, and he graduated from the law school magna cum laude. He is a former law clerk to the United States Supreme Court Justice Antonin Scalia, as well as a former law clerk to a federal judge, Michael Lutwig. Okay, so that's the panelists, and in addition to myself, you have the background of Cliff and I. I am a civil litigator. I'm an adjunct professor at Catholic University. I have a lot of my students here tonight, so thank you very much for joining me. Not that you had a choice. And so without that, I'm gonna turn this over to Judge Murphy. He's gonna sort of give you a brief introduction, and he'll moderate the panel. Thank you.
Thank you very much, Ann. We thought it best to approach the subject in this order. Professor Fishman, who has prepared a great outline that's in the material, will lead off discussing the existing clash, I guess, in the historical way that the clash between the government's duty to protect its citizens versus the individual's rights to be free of improper governmental intrusion has been handled. The case law and the statutes that have attempted to find this difficult to find balance. A quick look at the outline that Professor Fishman has prepared shows that he's going to take about 10 minutes today to do what would be done in a semester and a half in law school. He will lead off with that framework analysis. Janet will next discuss the most recent Supreme Court case and how the legislative response seems to be shaping up at this point. And we'll talk about the executive branch and private industry's use of tracking technology and discuss the potential downstream consequences for this tracking on the lives of, I guess, each and every one of us. And Cannon will look into his crystal ball and provide us with the potential responses of the federal judiciary to the cases that will be coming up in light of the Supreme Court's recent decision and in light of the federal legislation that may well be applicable in the very near future. We think that batting order works best, and we hope that we'll have time at the end of the presentations to answer any questions that you folks may have. So, without further ado, Cliff, please get us started.
Thank you, Judge. I've been litigating or teaching and writing about the Fourth Amendment since 1969. Sometimes it feels like I should say 1869. It's a source of endless fascination because, as the judge said, it shows how two of our firm's values are conflicting quite often: safety from criminals, safety from overreaching by the police. And the basic text of the rules governing search and seizure is the Fourth Amendment, which you see in the first paragraph on the first page of the handout. I'm not going to cover everything on my handout. It would take me 5 weeks to do so. That's about how long it takes me to cover just this part of the Fourth Amendment. But it's worth looking at the language of the Fourth Amendment, particularly the first phrase: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So the first thing we ask ourselves is, well, what are the terms we have to know the meaning of to understand what the Fourth Amendment protects? And of course the answer is, well, what is a search? What is a seizure? In most instances, the definition of a seizure is fairly simple: physically taking something away from someone or preventing him from exercising his normal right of ownership. But what constitutes a search is an enormous problem that the courts have spent decades trying to figure out, and I'll get to that in a moment. The other thing I want to point out to you about the Fourth Amendment is that it only regulates what the government does. It doesn't regulate what private industry does. It doesn't regulate what a private investigator does. It doesn't regulate what an individual who might want to snoop by breaking into somebody's home or researching about somebody online. And that's one of the topics that Ann has focused on in our treatise. And by the way, our treatise, Wiretapping and Eavesdropping, if you want about 4 feet of shelf space taken up, you can get a brochure for our treatise out on the table after the conference. So what is a search? That is the key issue. And let's just turn over to the second page of the handout, and that's what I'm going to focus on. Until 1967, the Supreme Court basically said a search by the government occurs only if the government has physically intruded into a constitutionally protected area. In essence, a trespass, a physical trespass. So obviously, if a police officer enters the home, that's a trespass. If they climb over a fence and go into your backyard, that's a trespass. But what if they, and so the government, knowing this, would use investigative techniques which would allow them to learn something about a subject, a target, a suspect, without physical trespass. And that's what happened in the case of Katz versus the United States in 1967. Katz was suspected of being a gambler, basically making a bookie. And he used a particular phone booth. Now, does anyone here remember what a phone booth was? It was this glass enclosed room, and you could actually close the door, and no one could hear what you were saying. And they knew that Katz used this phone booth every day at the same time, they thought, basically to lay off bets to somebody who's higher in the food chain of the gambling operation. So they put a concealed microphone on the outside of the phone booth, which allowed the police, the FBI, to hear Katz's half of the conversation. And sure enough, he was discussing the bets that he'd made and laying them off to a higher person in the food chain, and they used that evidence against him. He claimed that was an unlawful search, but of course the government had not intruded physically into the phone booth. What the Supreme Court said was the Fourth Amendment protects people, not places, that while what a person knowingly exposes to the public, even in his own home or office, is not constitutionally protected, what he seeks to preserve is private, even an area accessible to the public may be constitutionally protected. And while Katz was obviously visible to the entire world when he was in that glass-enclosed phone booth, when he shut the door, he had the right to expect that the unwanted ear could not hear what he said. And by planting the microphone on the outside of the phone booth, even though there was no physical intrusion, that was a search. Interestingly enough, the basic definition the Supreme Court's given of a search emerges from a concurring opinion by Justice Harlan. That's basically paragraph 3 in topic B on the outline. What Justice Harlan basically said is a search requires, that is, to establish that a search occurred, we have to ask ourselves, did the person about whom information was obtained demonstrate a subjective expectation of privacy? Was his conduct such that he thought and hoped he would not be overseen or overheard, or his property might be accessible? And was that expectation reasonable? And so the buzzwords which have defined the Fourth Amendment ever since really are, did the defendant have a reasonable expectation of privacy into which the police intruded? If this blue banner behind us was every way the police could learn something about you, only, let's say, the center part of it would be what the Fourth Amendment protects. So we have to ask, did a person have a reasonable expectation of privacy? If he did not, the police can do whatever they want to learn about him without implicating the Fourth Amendment at all. So if the police follow you and listen to what you say as you're talking to a friend, that's not a search, because when you speak in public, you run the risk you might be overheard. If you leave your windows open at night and a police officer walks by and looks into your ground floor apartment and sees a marijuana plant growing, that was not a search because you knowingly exposed the contents of your windowsill to anybody who walked by. So figuring out when a reasonable expectation of privacy exists is always the first issue we have to resolve in deciding, was there a search at all? Only if there was a search do we then ask, was it constitutional? All right. There are a couple of standard situations in which the court has said no search occurs. And again, we're in topic 4 on the second page. One was articulated in the Katz case, what a person knowingly exposes to the public is not constitutionally protected. And then number C is also very important. Whenever we convey information to someone as a matter of Fourth Amendment law, we assume the risk they'll betray us. If you tell a secret to your friend and she tells all of her friends, well, we've all lived through that. We've all had that happen to us, and we've probably all done it from time to time ourselves. But that reality means that if I confide in somebody, not knowing that somebody is really an undercover police officer or an erstwhile friend who's now become a police informant, I have no complaints if that person tells the police what I said. I have no Fourth Amendment complaint, even if that person was wired up and is recording everything I said. Okay, so those are some of the limits on the Fourth Amendment protection. If it fits into one of those categories of no reasonable expectation of privacy, police can do what they want with no restrictions. Next issue, use of surveillance technology. There are a couple of different trends the court has undertaken. One is that technology that's readily available to the general public, the police can use without it being a search. And such things as ubiquitous as a flashlight. I don't know of a single Supreme Court decision in which it held a police officer using a flashlight constitutes a search. So that, for example, if an officer walks by a parked car at night and is just curious with no particular reason, I want to look inside and see what's in it, she can shine her flashlight inside the car, and that's not a search, first of all, because it would be visible, the contents of the car would be visible at daytime, so it's knowingly exposed to the public, and second of all, since everybody has flashlights, you're not protected from their use. Binoculars, likewise. When you get into highly sophisticated surveillance equipment, of course, then the rules become somewhat different. And what the court held back in 2001, a very important case, Kylo versus United States, a decision by Justice Scalia, who, by the way, I describe as a closet civil libertarian. Everybody thinks Justice Scalia is this right-wing fanatic who foams at the mouth, and he's not. In many areas of the law, he is one of the primary defenders of individual rights, and Fourth Amendment being one, Sixth Amendment being another. Anyway, end of endorsement of Justice Scalia. He's also a brilliant writer and a very funny speaker. Katz did away with the constitutionally protected area concept until Kylo, when Justice Scalia, who's never liked the reasonable expectation of privacy test, brings back the Katz doctrine. He says the home has always been the heart of the Fourth Amendment protection. We have more protection from police intrusion constitutionally in the home than anywhere else. And that kind of makes sense. We know that intuitively. What happened in Kylo is the police had reason to believe, suspicion that Kylo was doing a marijuana grow operation, which, as you may or may not know, requires high-intensity plants to basically simulate sunlight. and it makes the marijuana grow quicker. So those things produce an awful lot of heat. To find out whether or not Kylo was doing this, they used a thermal imager, basically something which sees the heat emanations from the house, confirmed that there was an awful lot of, much more heat coming out of that house than any other on the block. They got a search warrant based on that. Supreme Court in Kylo says, no, that was a search. Using the thermal imager was a search, and he announces the rule that any use of surveillance technology, at least surveillance technology not readily available to the general public, to learn anything about the interior of the house is a search. And he says, while maybe the reasonable expectation of privacy test helps some, we really should base the Fourth Amendment primarily on fundamental principles that were recognized back when the Fourth Amendment was ratified, like you can't break into somebody's house. So anything you could not find out in the 1790s without a physical intrusion, you could not use modern technology to learn about the inside of a home without it being a search. So right now, we have a number of conflicting approaches to how we should define what a search is. There's the pre-Katz test revived in Kylo and the Katz test that I've been talking about before. There are other protections of privacy and against government intrusion besides the Fourth Amendment, and I've just listed a couple of the federal statutes very briefly. The federal wiretapping statute, which protects against wiretapping, bugging, intercepting emails and other electronic communications. It allows police to do that only if they get what I call a search warrant on steroids. Take what you normally need for a search warrant and make it 3 or 4 times harder to get a wiretap warrant. There's the Foreign Intelligence Surveillance Act, which is a world unto itself. It basically is a statute which allows the government to conduct all sorts of surveillance of Americans and others in the United States, not specifically to investigate criminal activity, but if you can establish, if the government can establish that the target is, quote, an agent of a foreign power to acquire foreign intelligence information. And there are miscellaneous statutes which Congress has from time to time passed to boost individual privacy as a result of certain Supreme Court decisions that were seen as eroding or intruding privacy. Now, when it comes to electronic tracking, until the case that we're going to be hearing about next, the Supreme Court had decided 2 cases back in 1983 and 87, the Knotts case and the Caro case. In each case, the government learned that somebody who they suspected was manufacturing methamphetamine had ordered a drum of chemicals which are necessary to cook up methamphetamine. In each case, they went to the chemical supply company and said, let us put an electronic beeper in the drum of chemicals so that once you sell that drum to this particular person, we can use that to follow where the drum is being taken. In each case, the chemical supply company agreed. The government used the beeper in part to follow the drum of chemicals in the car in which it was placed from the chemical supply company to its ultimate destination. The Supreme Court said first that installing the beeper wasn't a search or a seizure because at the time they installed it, the drum of chemicals wasn't the property of the target yet. Using the beeper to follow the car through the streets to its destination wasn't a search because where a person drives in his car is information knowingly exposed to the public, and so the information itself wasn't protected at all. And finally, to continue to monitor the beeper once it gets to a private location is a search of that location, which requires a search warrant. Now, the surveillance in Knotts and Caro, we're talking about maybe a day, maybe 12 hours, maybe a day and a half of actual following the car. And the court said that if we have much more intensive surveillance, that'll be a different case, and we'll worry about such a case if such a case arises. And I think that would be an excellent time to turn the case over to Jana, who's going to talk about the most recent decision.
So first, thank you all for coming. I'm going to start with some real-world, you can all hear me, right? Real-world examples in this arena and why it's important. About a year ago, during the holiday shopping season, there were 2 malls in the United States, one in California, one in Richmond, Virginia, that established what essentially was a tracking device with a company called Path Intelligence. If you had your cell phone on when you were in the shopping mall, it could track you, not individually as a person, but you didn't have your identity, but it had you as a person, and what it did was it looked to see where you went in the mall and what advertisements you were drawn to, what shops you were drawn to, and they used it as customer data. Well, Congress got wind of that, and Senator Schumer from New York said, no way, you can't just have something that a customer can just opt out by turning off his or her cell phone. That's too much privacy infringement, even if you're not collecting individual information, even if you're not looking at data on the cell phones. You can't do that. Path Intelligence, which was a British company, stood down for the time being. Around the same time, there was a company called Carrier IQ. It was doing a little bit more. It was a wireless software provider that provided software to various cell phones, not Apple, in case some of you worried, but Samsung, Huawei, a couple of others. What was it? Pantech and HTC. And this is important because with the software, all of your calls, your text messages, your geolocation was sent back to Carrier IQ through its software. Wasn't necessarily using it for anything, but your information was there. And Carrier IQ was hauled before Congress. A couple of subcommittees were investigating them. And currently, they're being sued by various consumers in class actions that have been consolidated in California. So these things are going on in the real world today. And this is tracking where you probably don't know what's happening. So I'm assuming a lot of you willingly take part in geolocation by having daily deals through Groupon, by doing something on your cell phone that tracks where you are, and you do it for your own convenience. But the issue today is when do you consent to that and when don't you consent to that? Now, the case that the professor was talking about, Professor Fishman was talking about, that I'd be describing is called United States versus Jones. And Cannon's going to go into that in more detail. But what that was a case where the government put a slap-on GPS device onto an individual's vehicle to track where he was going. The government said did not need a warrant because it was just following him on public streets. Court said, no, that's a physical intrusion. Like Professor Fishman said, it's a trespass. When you put the slap-on, that was the physical intrusion that triggered the Fourth Amendment and the search requirements, and you needed a warrant. So lately, though, a court in the Sixth Circuit, and that's as high as I believe it's gotten so far in terms of what courts have addressed this issue. The geolocation that we were just talking about, where people are tracking you and your devices, that's at the Sixth Circuit. Sixth Circuit in a case called U.S. v. Skinner has said, nope, that's not you don't need a warrant for that. That's not a physical intrusion. That's not a trespass. And you can basically, in that case, the government was tracking someone real time on his cell phone while he had it on. So it wasn't looking at past records. It was just following this person on the cell phone. And so the issue today is, where is that going to lead us? We have two types of cell phone tracking: historical records, which could look at your past locations and your past text messages, and real time, which means if you've got your cell phone on and you're walking around, then all the cell towers that are around us, where you get your reception, they use this method called triangulation to actually locate you. And the more urban the area, the more cell towers, the more specific it can get. So they can locate you and find where you are, and where's the breakdown, right? Like, is the shopping mall okay? Is a public street okay? But when you go into your house, is that okay? And the courts have not come to a conclusion on that as to what's needed. Do you need a warrant for that? When do you? Or is it something, a lesser standard? Is it just relevant to a criminal investigation? Is it articulable facts? And I'm going to have Cannon look into his crystal ball as to what the courts are going to find out about that. But in the meantime, what Congress has attempted to do, and I have to say, I'm here, I'm on the Intel Committee. None of this pending legislation has come out of the Intel Committee. It's all been judiciary or something else, so I want to make that absolutely clear that none of this legislation has anything to do with my particular committee at this point. But they're important because they've been introduced, and what they require is some of the legislation requires the government to get a warrant to track people. Some requires private industry to give notice and get consent from consumers before doing this geolocation. These bills are all over the place as to what exceptions can apply. It can be an exception in national emergency. FISA, as Professor Fishman pointed out, is for terrorism and agents of a foreign power. There are exceptions there. But basically what they all try to do is have some sort of method so that people aren't walking around shopping malls not knowing if they're being tracked for something. There has to be some form of consent, or if it's the government, there has to be some warrant involved. But, you know, Congress hasn't made up its mind. There isn't a clear majority on what should happen and how far it should go in terms of tracking people and in terms of enabling, you know, companies to do this, because, you know, they're saying, hey, this is what consumers want. But is it really what you want? And are you giving knowing consent to all of this? So what standards should be in place? It's unclear. I mean, the big issue is that what do you want, though, right? Like, you want some of these things for your own convenience. You want to be able to get the daily deals. You want to be able to geolocate where's the closest movie theater that's showing the movie I want, you know. But how far can you go? Like, how far can you say, well, this is what I want to do, but no, it's not public. Don't track me. So that's a dilemma. I mean, that's what the courts are, that's what's going to face the courts. That's what hits Congress. And then once Congress passes something, it'll be challenged in the courts, no doubt. But in the meantime, the problem is that when you legislate, you can't always account for future technology. And that has tied our hands in a lot of things. FISA, the terrorist statute, was 1978. It cannot cover everything that you need to cover for all time because you don't have a crystal ball. Well, Cannon does.
Apparently, because everyone says
I
that
can't
I
wait
do.
for Cannon to talk.
Right, we're
Right.
looking forward to this.
But the problem is, you didn't know even about cell phones back in 1978. And so you're trying to legislate for all time, not knowing what's coming down the pipeline. But criminals are going to use the new technology. Bad guys are going to use the new technology. And you're going to have to be able to account for that somehow. But at the same point in time, we don't want a world where all bets are off and everybody can be tracked wherever they are. So it's definitely an issue that, you know, I'm glad we have professorial minds on it. I'm glad we have practitioners on it because there's no easy solution. But it's a hugely interesting issue. And you guys are so lucky you are where you are in your careers to be starting on this, because there was no social media back when I was in law school. And now it's a whole new legal practice unto itself. And it's much more interesting.
Was
than,
no TV or radio, no. Not quite.
I mean, it's so interesting, you know. I mean, you know, just say, you know, Facebook, discuss. I mean, it's got all of those issues on it, and you know, you guys are lucky. You're just embarking onto this now. I mean, I'm telling you. So, in any event, with that, I'm going to turn it over to Anne.
All right,
to,
great. Thank
jump
you,
on in.
Janet. Okay, so Cliff gave us a great background on this constitutional framework and the Fourth Amendment and these questions of searching and tracking. And he talked about the original beeper cases, which I wasn't alive yet, but he was, and he was taking care of the law for us. But so we've heard about this GPS tracking, all right, and a beeper tracking, GPS tracking, and then cellular tracking, which Janet talked on, and she talked about this example of the malls. But I want to talk a little bit about evolving that tracking beyond just these devices, but actually using the human body for tracking. And so I'm going to talk about biometric tracking. And this is something that there is a complete absence of legislation. When Janet says, you know, we don't really have clear legislation talking about cellular tracking, it's really, and she concludes with, we don't know where the technology is going. The future really is biometric tracking. So we'll look at it. We've got the GPS tracking, and we have that United States Supreme Court case called Jones, which says can't track for 28 days without a warrant when you're going to physically attach the device to a car. Okay, that's a violation of the Fourth Amendment. We then have the Sixth Circuit Skinner decision saying, yeah, but you can track someone with their cell phone using their geolocation data if they're in public places. So we talked about, Cliff gave us that really great background about that your reasonable expectations of privacy and what you knowingly expose to the public. So the Sixth Circuit has said to us, hey, it's okay to use geolocation tracking through cell phones, and Janet talked about triangulation, but almost all smartphones today actually use GPS-based tracking, which tends to be a little more accurate. But biometrics, I'm using this term, what the heck am I talking about? When we say biometrics, we're talking about not just your physical biometrics, it's two different things. So it's a characteristic, meaning your facial feature, it might be your iris pattern, it might be your vein pattern, and we also talk about it as an automated process. And the process is actually the software technology and hardware that we use to identify someone by biometrics. So what are we talking about when we talk about biometrics? The most pressing thing for privacy right now is facial recognition software or face recognition technology. And what that does is it just takes the measurements of your face from any digital photo. If you have a software program, it records your facial biometrics, and you can be identified at any point where there is a digital image being taken of you. And where is that happening? Every day of your life when you walk down any major city, in any street, your facial biometrics are being taken. So when we go back again to these concepts, though, of privacy, go back to what Cliff Fishman was talking to us about, knowingly exposed to the public. This is a problem with our American law. Our faces are clearly knowingly exposed to the public when we walk down the street. But we have the Supreme Court who's just said to us in all three opinions that the court issued by Justices Scalia, Justice Alito, and Justice Sotomayor, that when we allow the government to kind of just consolidate all of this data, that they know where we are at all times, all three justices said this is not acceptable under the Fourth Amendment. They all exhibited clear discomfort. And there was Justice Alito practically got down on his knees and said, Congress, please pass legislation. Help us. We don't know what to do. They're not even sure how cell phones work, much less biometric technology. So we have this government involvement and push behind biometrics because it is just a very powerful tool. And we have private industry using biometrics. So Facebook, for instance, has over 900 million users. Every time a photo is uploaded to Facebook, your facial biometrics are scanned, okay? And at that point, Facebook has you in a database where your facial biometrics are recognized. What does Facebook want to do with that information? Facebook wants to sell your biometrics. Why? Because they can show at any point, at any time in a photo, oh, this person's wearing Levi's. And they don't just categorize it by who you are. You're clumped into gender categories, age categories. So the marketing potential behind this is massive, and it's not just something in the future. It's clearly happening now. One of Senator Franken, who has one of the bills, who's proposed one of the bills that Janet referenced briefly, he really wants to control private industry use of that. So his point is, let's not just control what the government can do, which is the Fourth Amendment that Cliff talked about, but let's control what private industry can do, all right? And let's protect our data. Some critics say we're already past that. We're past that point. The data has been collected. Your facial biometrics are collected. Everywhere you go, this has already been assembled, and so you can be identified at any point, anytime, any place. The European Union has been much more aggressive about that, though. They are challenging Facebook right now. As of September, Facebook is under investigation in Germany. It's under investigation in Ireland. Facebook is headquartered in Ireland and is insisting that its facial recognition practices don't violate any kind of privacy. But this again goes back to, we have a complete absence of congressional legislation. There is no real push for congressional legislation because the financial incentives behind the ability to use biometrics as a tracking device is enormous. And so think about, when we talk about biometrics as tracking, we have GPSs, which help us track cars. We have cell phones that have our GPSs, which they're used to track your geolocation. When you go on the internet, software programs track every site you go to. You have cookies put on your computer, so all of your online behavioral preferences are noted, so you can be targeted with advertising. Biometrics does for the human body what software cookies and software programs do for tracking people on computers, and what GPS does for tracking cars and cell phones. So understand, it's the ultimate form of tracking. It's the most invasive form of tracking, and yet at the same time, we have this dichotomy. We are knowingly exposing our physical attributes every day, every time we step out the door of our house. But does that mean that think of the overlap of surveillance that's everywhere. Catholic University has surveillance cameras everywhere you go. We're in the National Press Club. We're surrounded by surveillance cameras. We're a couple blocks from the White House. So at any given point, when we collaborate this data between private industry and the government, at all times you can be identified where you are, meaning a mosaic is very easily assembled of where you are, who you're with, what clubs you're going into, whether you're seeing a counselor, whether you've walked into an abortion clinic. And that is biometric tracking at its present level. It's not the future, it's not Minority Report. So this is, in terms of legislation, as Janet says, this is an exciting time for you all. It really is, though. It's exciting for all of the lawyers that are doing this, and it's something that coming up with policy is really important. One of the things that Janet gave you some very good examples of malls that you'd walk into and they would use your geolocation data to track you. There is actually a Facebook collaboration with a company called Red Pepper. And Red Pepper combines face recognition technology, cameras, and Facebook users, so that a business that participates in Red Pepper and uses these face deals, which is what it's called through Facebook, basically installs a camera in their site of business. If you walk in the door and you're a Facebook user, you want to participate in face deals, which is like the more modern form of Groupon, you would immediately get a Facebook message. You are identified, your biometrics are scanned, and they say, oh, you're here in the store, and here's the specials we have. Or you're in the restaurant, and here's the specials we have. This isn't the future. This is happening now. It is a company that is making money doing this, and there's nothing stopping it, no legislation. So not just, and I want to wrap up, I know our time is short, but this isn't just a lack of legislation. There's also a very strong interest in the government in collaborating with private industry and developing biometric technologies. Why? Because post 9/11, there was a huge initiative to protect our borders, and one of the ways of doing that is to recognizing if we can identify who all people are at all times, we substantially increase our ability to stop any kind of terrorist threat on our homeland. So the executive branch has a very strong motivation and is very aggressive in it. And there's been a cabinet-level council that was established called the National Science and Technology Council. As part of that, there's a subcommittee that is the Biometric Identity Management Agency. And very clearly, without any question of what their they have a website, www.biometrics.gov, that they clearly state their goals. And when you read their goals and you think about what your fundamental notions as an American citizen are of privacy, it's really pretty shocking that this is an executive branch policy, and yet at the same time, they're not violating any laws. There's no legislation to stop this. But those goals are to further developing modular plug-and-play software to accommodate the increasingly prolific number of diverse biometric capture devices, because the increasing number of devices and the different software and hardware systems that collect different biometric data pose challenges. So what that is they want to not just they want to have a uniform system for all biometric collections, so that your irises, your facial recognition, your vein structure, that all of these systems can work together, whether it's a local law enforcement who has a small handheld camera. The small handheld camera could immediately scan your iris. It's just a snapshot, your face, identify you. There are now rapid DNA machines, again, which are being developed in small handheld devices, which would clearly identify you specifically, and not just who you are, but definitely that's your child and that's your mother with you. So one of these things is to improve biometric systems to collect and process large amounts of biometric data quickly, increase the use of handheld biometric devices by law enforcement and national security, develop data-level capture countermeasures to increase incidents of identity avoidance, improve and acquire to increase the ease of use, acceptance, and put through for cooperative users of civil and commercial systems to collect biometric data. And so what that is, when they say civil and commercial systems, they want to connect Facebook's biometric data on you and the federal government, local government, in a collaborative effort from state, local, and federal law enforcement and international law enforcement, so that at all times we can be in what the White House describes as sustained situational awareness. And what sustained situational awareness is the ability to ascertain who anyone is at a crowd at any time, so that if anything needs to be done in response for both security, health concerns, there can be immediate response. And the goal is to make sure that folks can be identified at all times, at all places. So in terms of this void and what these concerns are, I'm going to let Cannon turn to that. I'll conclude with one thing, which I thought in talking with Judge Murphy about this over the last few weeks, we're really kind of 5 to 10 years away probably from biometrics coming through the courts. And yet at the same time, it is a technology that is being used every single day. It is not Minority Report. It's where we are. So, Cannon, turn that over to you.
Great. Well, thanks, Ann, and it's a pleasure to be here tonight. And I'm a little bit intimidated, frankly, because all of these promises have been made about my crystal ball. And I don't think I'm going to have any really specific predictions. But my task on this panel, at least as I understand it, is to talk a little bit about how the courts are reacting to all of this and how I think the courts will react, particularly the Supreme Court. And that's really going to be my focus over the next 10 minutes or so. You know, I should start by saying that there's always been something about the Fourth Amendment where the Supreme Court is concerned, and the court has always seemed to have a particular interest in superintending the bounds of the Fourth Amendment, its application in the numerous permutations of situations in which Fourth Amendment values are potentially implicated. And the current Supreme Court is really no different. I mean, this term before the Supreme Court, which I think has the potential in many ways to be one of the biggest terms in recent years, is really a Fourth Amendment term. The court has about 40 cases on its docket already. 5 of those cases are Fourth Amendment cases. I've actually argued one of them. I'm going to be arguing another one later on in the term, and I'll allude to those cases very briefly in the course of my remarks. But the court continues to just show an interest in this area of the law, and I think it's not just because these cases are fun and easily accessible. They tend to involve issues that everyone can understand, which puts these cases in marked contrast to the majority of the cases that the court hears, which are cases about, Section 504A1, B3 of ERISA and issues like that. The Fourth Amendment cases are interesting. I think the court finds them interesting, but I think the court is also very cognizant of the fact that there are all of these new factual situations where traditional Fourth Amendment principles may not apply as comfortably, and the court is really beginning to struggle with how to reconcile traditional Fourth Amendment principles with all of these various situations, including the situations involving geolocation and biometrics that we've been discussing today. As Janet indicated, the court's most recent foray into this general area was in the Jones case. I happened to be in the court on the day that it was argued. I was actually arguing the next case that day, so I was kind of paying about 50% attention to what was going on and about 50% attention to trying to figure out what I was going to say. Sitting here right now, I wish I'd paid a little closer attention to it, but I paid enough attention to it to have a pretty good sense, I think, of the dynamic at oral argument, kind of above and beyond what ended up being reflected in the court's opinion. This was an interesting case for any number of reasons. This was a case that the government actually voluntarily took to the Supreme Court, which is a little bit surprising in hindsight, since the government ended up getting exactly 0 votes in this case. In many ways, it was sort of an atmospherically bad case to take to the Supreme Court, because this was the case in which the government had actually applied for a warrant, but the warrant had actually expired the day before the government attached this GPS tracking device. So the government was in the somewhat uncomfortable position of arguing that their seeking a warrant was kind of a nicety, but not really constitutionally required. And I think that was one of many facts about the case that ended up rendering it a less than optimal vehicle for Supreme Court review, at least from the government standpoint. There was not a very deep circuit conflict on this question of whether the attachment and use of these devices was consistent with the Fourth Amendment. Usually the Supreme Court likes to see, broad disagreement in the lower courts before it grants review, but there were only really a couple of circuits that had weighed in on this issue. I suspect that the court granted review because it thought, well, here's a kind of interesting question involving a cool new technology. Let's try to figure out how the Fourth Amendment works in this area. Well, during the oral argument, it became clear pretty quickly that the court had figured out that GPS tracking devices were not really the cool new technology. They were kind of yesterday's news. And there were a lot of questions at the oral argument about some of the technologies we've been discussing today. There were questions about the use of geolocation. There were questions about closed-circuit television and the fact that, at least for those of us who drive around Washington, there seems to be a CCTV camera attached to virtually every single traffic light, much less every single building. And so I think the court realized in many ways during the oral argument, and I'm sure that the court got a sense of this through the briefing in the case, that whatever it said in the specific context of GPS tracking devices was likely to have applicability to technologies that the court felt that it only had a really modest understanding of. And I think that that's what ended up driving the outcome in the case. I think that the court's opinion in this case was actually a very narrow opinion. Basically, the only question that the court ended up deciding was whether the attachment and use of the device, the long-term use of the device, constituted a search for Fourth Amendment purposes, therefore triggering the protections of the Fourth Amendment. The court really didn't speak to the question of whether or not a warrant is required, whether or not probable cause is required, or something less. And the court, essentially did that by saying, well, look, there's a search here, and the government's basically waived any other argument in the course of this litigation. And so if we say that there's a search, that's basically all that we have to do in order to decide this case. And I think in many ways what happened in Jones kind of reflects the great luxury of being on the Supreme Court. Not only do you get to take a nice long summer vacation, but you get to decide not only which cases you're going to hear, but how broadly you're going to decide them. And I think the Supreme Court has a much greater luxury in that regard than lower courts do, and I think that's reflected in the Skinner decision, which Janet referred to, where the Sixth Circuit really did kind of directly confront the question of how to analyze geolocation information, where that information is obtained from a cell phone that's being used in public areas. And I think lower courts, number one, have no discretion in essence about which cases they hear, and number two, I do feel a much greater obligation to actually definitively resolve those cases and not to say, well, we're going to leave some aspects of this for another day. Let me just say a word about what's currently before the court and then make a little bit of a prediction as promised. I think in many ways the cases that are currently before the court test various aspects of a kind of fundamental dichotomy in the way that the court talks about Fourth Amendment cases. And this is really very well captured in the first page of Professor Fishman's outline. The traditional mode of Fourth Amendment analysis is that when you're conducting a search or a seizure, you typically need to have a warrant, and you need to have a warrant that is based on probable cause. And that is the familiar thing that hopefully most of you learned in the first day or among the very first days of criminal procedure, because that is kind of the default mode of Fourth Amendment analysis. At the same time, there are a range of contexts in which the court has either dispensed with the warrant requirement or engaged in something more akin to kind of full-fledged balancing of privacy and government interests, such as the interest in officer safety. And really both of the cases that I'm arguing this year test that proposition. The first was a case I argued a couple weeks ago called Bailey versus United States, which involves the scope of the court's rule from an earlier case called Michigan versus Summers, which is the case that basically sets out a categorical rule that you can detain the occupants of a house for the duration of the execution of a search warrant at that house. The question in the Bailey case was whether that rule applies where police see an individual leaving the house before they execute the warrant and they proceed to tail the individual and detain him. And the question in the case was really whether the police can do that absent probable cause or even individualized suspicion. In other words, the question was basically where does this categorical rule end and where do ordinary Fourth Amendment principles apply? The other case that I think is really going to test this principle is a case that the court granted review in last week. It's actually from Judge Murphy's former court. It's a case called Maryland versus King on the question of whether a state statute that permits the collection and analysis of DNA from arrestees, so individuals who have been arrested but not yet convicted of a violent crime, without a warrant is consistent with the Fourth Amendment. These are typically cases in which the police collect the DNA not to aid in the investigation of the crime of arrest, but rather in an effort to solve other crimes, that is to say crimes as to which there is no degree of suspicion with regard to that particular individual. The state makes the argument that if you're an arrestee, you're in the world of kind of full-fledged Fourth Amendment balancing. I suspect in our merits brief we will make the argument that arrestees fall on the kind of public citizen side of the line. They're not analogous to individuals who have actually been convicted and therefore almost by definition, have lessened Fourth Amendment protections, and therefore you need to have a warrant and probable cause, and that will really be a large focus of the argument. Well, this issue really is playing out in all of these contexts of the law, and when you look at some of these issues that we've been discussing today, you see this same sort of theme. You know, do you need a warrant when you're talking about information that has been voluntarily disclosed to some third party? Do you need probable cause, or can you have some lower degree of suspicion? And and I think what's really interesting is that a lot of these contexts test the proposition that this is really all about reasonable expectations of privacy. Because what's often going on is you have information that is public information at some impossibly high level of generality. As Ann pointed out, when you're in public, you expose your face to the world. You certainly expose your location to the world. But there comes a point at which this information gets collected in a way that is, kind of spooky or creepy, for lack of a better word. And then you're in the world of what's been referred to as the mosaic theory. There's something about the collection of all of this information that perhaps creates an exception to the ordinary mode of analysis, or at least creates a sort of discrete basis for Fourth Amendment protection. And that was what Justice Alito seemed to be driving at in his separate opinion in Jones, but it's not entirely clear that that principle will command a majority of the court in other contexts. The Jones case itself really did have these two very different theories for reaching the same result, and it's very hard to know as a systematic matter how that's going to work going forward. And I just think that we're living in a time when we're all going through a heightened sensitivity to the amount of information that we're exposing. I actually think that the current scandal involving General Petraeus, to me, kind of drives this home every day when you read about the information that the FBI obtained and how they were able to link up, access to a Gmail account to particular computers. I happen to be just messing around on my Google account, and if you actually click around in the security features, there's actually a place where you can click and see all of the places where your account has been accessed from over, I think, like the last 28 days. And I was just like, wow, I've been to a lot of interesting places. Thankfully, they all seem to be places where I, in fact, had been. So there was not some Chinese hacker accessing my account. But the amount of information that is out there is astonishing. And the thing about reasonable expectations of privacy is that I think we all know at some level that there is a lot of information out there. We all carry around these GPS tracking devices in our pockets, but I'm not sure any of us really has a very good sense of just how much information there is. I think if you polled the average American, they would have no idea that the types of information that Ann was talking about are being exposed to the world at large, and that's where this traditional framework, I think, starts to break down around the edges. So it's an incredibly interesting time. I think it's almost inevitable that over the next 5 or 10 years, the Supreme Court is going to confront many of the issues we've been discussing today. The lower courts are starting to confront it already. I think in many ways the most interesting question will be, how eager is the Supreme Court going to be to kind of reach out and start deciding some of these issues? Or to what extent is the court going to be content to allow them to percolate in the lower courts, perhaps out of a concern that if the court weighs in too early, it's going to do something ill-advised or rule too broadly in a way that could prove to be harmful in future cases. So that's not necessarily a prediction so much as it is just a thought about where all of this is going.
We don't
And
need
this-
to dim the lights for the crystal ball.
I don't think so.
There's also going to be impact in the coming years with respect to this in civil litigation. In domestic relations cases now, when lawyers begin to get their discovery tools out of their toolbox, they want the other side's emails, they want the other side's information on Facebook, they want Easy Pass and GPS information. I was in a case as a mediator a couple of months ago, and it involved a domestic case in which one of the spouses thought the other spouse was cheating. So that spouse, the suspicious spouse, I'll say, hired a private investigator who put a GPS device on the bottom of the suspect spouse's automobile. Well, the suspect spouse found out about it and stuck it on somebody else's automobile. Sent the detective into the hills of North Carolina trying to trace down somebody who was a complete stranger to the litigation. In situations in which there are going to be civil lawsuits against these companies for acquiring this information without authorization, we'll see where the courts go. And also, I think we may see, under the little laboratories of democracy theory, many states and state legislators looking at these problems to see if they can come up with a solution that will be satisfactory in that state. Obviously, when the federales speak, the supremacy clause will provide that the federal legislation would trump any state legislation. But in the area, just as an example of electronic surveillance, Maryland has a statute that requires two-party consent to a recorded conversation. The federal statute says one-party consent. In a Maryland courtroom, a one-party consent conversation is inadmissible evidence by statute, even though it would be admissible in federal court. And the federal cases in this area have said that if the state has a more restrictive statute, then that statute will not be overruled by conflicting federal legislation when the case is in the state court. So I think we may see in the future some interest by the state legislatures in the kinds of problems that the panelists have discussed today. So look for that. State legislators are often very interested in the area of privacy and want to do something to protect their citizens from overreaching intrusion, not necessarily overreaching governmental intrusion, but overreaching intrusion from other private parties. But I pose a question to our panelists so that they can respond, and then we can take some questions from you folks. What is left of privacy, given all of the tremendous advances in these detection techniques? Why don't we just go right down the list? Ann?
Okay, so I think you could take a cynical view and say there is nothing left of privacy because the data has in fact been collected. But if we look to our European and Canadian counterparts and what they're doing to regulate this and protect this, there are a couple solutions, and one is legislation involving do not track, meaning legislation that prevents private industry and government from tracking your online activities or your activities as you walk around through, say, face recognition technology or things like that. Another is, and again, I gave the example of Europe is cracking down on Facebook and saying you have to delete all of your facial biometric databases. They're not just saying you can't do it, they're saying delete the data. So if we're going to have privacy, and I think we still can, or it really does become the Orwellian society that we read about in 1984, unless we follow those models of do not track and we follow models that regulate how long data can be retained and what purposes that data that is retained can be used for, right? So limit and control the data and how it can be used. And then the other thing is that as individuals, Cannon made the excellent point, most people have no idea how much data is gathered about them. And individuals need to be given very easy access to see what is gathered about me, what is in the hands of private industry, what is in the hands of the federal government. And there is federal legislation, the Privacy Act, which actually does allow citizens to see what kind of information the federal government has. But there should be a counterpart to that for private industry, because it is private industry that has amassed the data. So I think that there is no privacy unless there's going to be legislation. And that's why having panels like this and generating these discussions is hopefully going to actually allow us to preserve privacy. And I will say one last thing about the Supreme Court. When you read Justices Alito, Sotomayor's, and Scalia's opinions, Cannon's right in the sense of this opinion is a very narrow opinion, but yet what these justices go on about in their dicta is justices that are alarmed by the technology and they're alarmed by the complete destruction of privacy as we as Americans traditionally think of it. And so I think that is a hopeful sign for the future of privacy.
I tend to agree with Ann, although I'm a bit more pessimistic. I think realistically, the only thing that you can do to preserve your privacy is to be so boring and so unnoticeable and so uninteresting that nobody decides to find out about you. If somebody wants to investigate you, they can find out virtually everything, every fact about you, going online and really without even having to use some of the more sophisticated devices that we've been talking about.
He does pay cash for things.
Yeah,
in case you're
I pay
wondering.
cash. I don't have a smartphone. I don't use the courtesy card in the pharmacy or the supermarket so they can get the bonuses. My wife does, so I don't know what I'm accomplishing. but I seriously, I don't register my Metro card because I don't want them to have a permanent record of every Metro station I use. And if that means if I lose my card and I lose the deposits left on the card, I'd rather do that than have a permanent record of every Metro station I ever went through with this particular card, because that record is being kept by the Metro computers. That's one of the things that you give up when you register your card. And be aware of the degree to which you are surrendering privacy. I tell my students, don't put anything in an email you wouldn't be willing to see on the front page of the Metro section. Because if you become caught up in a scandal, however innocently, everything about you becomes public. What about the woman who got these anonymous threatening emails and went to the FBI? Her name's now out in public and people are speculating, well, did she have a relationship with this other general? And let the media or let bloggers decide you're interesting to them, and your life becomes an open book to anybody who goes online and checks. Now, maybe some of the legislation that the European authorities have passed will give us back some of the privacy, but I think we're shoveling against the tide. A real happy thought, but that's what I see.
Janet?
Your thoughts are happy compared to mine, because I think privacy is going to be dictated based on reality and based on what events. If we have another 9/11, people are going to be like, fine, search me, do whatever you need so I'll be safe. I think, it's been some time since 9/11, so as the years go by, we get less and less concerned about terrorism, but you don't know what didn't happen, right? So you don't know what was prevented. If something else happens, and it will probably be in the cybersecurity sphere now, you're going to say, fine, look at my financial records, do what you need to do, just ensure that I'm safe, ensure that you don't hit me, ensure that you don't hit my energy grid, my water supply, my everything. You can have my information. So I think that it will be tested by real events. I think it also will be based on consumers. If somebody says, we're going to track you through a shopping mall, you're like, no, you're not. Well, we're going to pay you if we can track you through a shopping mall. Oh, how much? I think it is going to be tested based on what people are willing to give up for, I don't know, a reward, an incentive, and also how threatened you feel in day-to-day society. And I think, it's, again, makes your thoughts look happy, but it's the reality of things, I think, to come. Please get happier.
I
Please
don't know if this
bring
is-
some light back to the room.
I don't know if this is happy or sad, but it's just a sort of a sociological observation. I just sort of have this sense that with younger generations, there is truly a lower expectation of privacy because younger generations are willing to put a greater degree of information on the internet about themselves. And I think that in part that may be because of a greater comfort level with the technology. But I do think that if you asked an average 21-year-old and an average 65-year-old what types of information they view as private, you would get very different answers. And so, it remains to be seen how that's going to influence the development of the law. The people who tend to decide the development of the law are a lot closer to 65 than they are to 21, by and large. Those on the Supreme Court are, for the most part, over it or close to a 65. And so, it'll be interesting to see to what extent this sort of generational issue colors the way that Congress and the courts go about analyzing this. The only other observation I would make is that it does feel as if there are choices for people who don't want to make certain types of information available short of going the Professor Fishman route and, just disconnecting from the grid entirely. I'm not even sure if that's Professor Fishman's real face or whether he's engaged in biometric disguise here. But leaving that aside, there's an interesting story.
Actually, I'm 27 years old. This is like...
Well, I would have thought that even with that face. But there was a very interesting story, I think it was in the Post over the weekend, about this new search engine that just advertises itself as not collecting any information about the search.
DuckDuckGo, I think it's
Yes, it's called, I believe, DuckDuckGo, and it'll be, it was a very interesting article because it was all about how this search engine came to be. But I guess my reaction in thinking about it was just kind of wondering to what extent people, in fact, will choose to use this search engine, or whether people really care about the fact that a variety of the perhaps better-known search engines do collect information about what you search for, and they do alter your searches based on what you've searched for in the past. I think many people may view that as affirmatively desirable. So again, in some sense, you get the privacy you ask for, and I think over time, people are getting more sophisticated about what's actually taking place, and I think all of us know a lot more about what information is being collected about us than we did, say, a year or 2 or 5 years ago.
Which is a hopeful sign.
And the cases that the professor mentioned, the civil cases that have been consolidated out in, I know it's the Ninth Circuit, I'm not sure which district court it is out there, but you may find a lot of arguments pro and con consistent with what Cannon just mentioned. I mean, you can see a jury saying, okay, they gathered data on these people, but so what? I mean, come on, all they did was do the same thing that could be done if somebody took the time to follow them around the mall from store to store to store. So, I mean, what kind of damages are we talking about here? I mean, you could see a case where, they return a nominal damage award to somebody who's asking for $1 million because he or she didn't know, hey, my cell phone was a source of information being tracked by these people. It's very interesting, I think, and you folks, as Ann mentioned, and I guess Janet too, to be in the position you are, about to come out and begin to practice law at a time when things are developing so fast is really interesting. It may be difficult, but it certainly will be interesting. If anybody has any questions, we still have time for some. If you'd like to pose a particular question to a member of the panel or offer a comment generally.
Who'll be the first?
Question about this idea of thank you. The younger generation is more comfortable sharing information to a certain degree. Facebook used to be just for college students. It wasn't like MySpace reaching for everyone, and more importantly, the parents weren't on there either. So there was this sense of sharing information on Facebook is, if nothing else, by obscurity, just between me and my friends. So that's kind of the idea of, yes, it is sharing, but it's not sharing with everyone. Are you hearing any traction? Are you thinking there's going to be ever a realization that the idea of there's something more than the dichotomy of not sharing it at all and sharing it with all and sundry, including the government, and permanently as well? It's not just the distribution, it's the permanency. Is anyone going to be able to make that distinction usefully, at this point, either against the government or against the private sector, which are two different battles?
It's actually easier to make a case and put restrictions on the private government because the government's resources are quite finite compared to private industry, really, in terms of the profit motive that private industry has to gather and accumulate and sell this information is incredible. And it's harder to legislate against private industry than it is the government as well, because the government can control its own behavior. Congress can basically say, Justice Department, you cannot do A, B, or C, and that's fairly clearly laid out, whereas it's harder to do that in private industry. I think one of the problems is that we've been trying since 1968, when the first wiretapping statute was to protect privacy by regulating technology. And I think what we need to do is figure out a way to define what privacy should be. What sorts of information about you should be private, and then say no matter how private industry or the government goes about trying to get it, that's still unlawful. As long as we keep trying to do it by regulating technology, the statute will be obsolete within a month or two after it's passed, because technology is exploding every day. All sorts of new sorts of communications and surveillance equipment is available. So we've got to rethink the entire model, not focus on how is this information being acquired, but what information simply should be off limits, period, A, to the government, B, to private industry. And of course, is it practical to make certain information off limits, since if the technology is so ubiquitous that it's impossible to really regulate? Those are some of the problems we have to address. And I don't know if we can address them successfully or not, but I'd rather start thinking about it in terms of what do we want to protect rather than what technology should we regulate in which way.
Cliff and I have been writing and researching about this together.
And fighting about it, too.
Yeah, a lot of fights about it since 1995. And so I laughed when I heard Cliff say we have to legislate to technology, because that was something we early on arrived at this conclusion. And the really difficult thing, which is it connects what Cliff's saying with what Cannon spoke to a few minutes ago. When we have differing ideas about what we consider to be protected. So a traditional notion in all of these cases that didn't come up before is that we protect content of communications more so than we protect the routing information associated with that communication. So meaning we traditionally think of something having a higher Fourth Amendment protection if it's the actual content of the email versus the routing address of the email. Or the phone number you dial with your phone isn't protected by the Fourth Amendment the way the conversation, the actual phone conversation you have is. So but when we go to define what we think, Preston, of this notion of what is protected, that's where I think the legislation stalls, because there are these incredibly different notions of what we consider to be private. And a 65-year-old person has a very different notion of what is a private thing that should be protected. And these traditional notions of content and non-content blur as the technology advances further. So I don't know if that responds, but if you have a follow-up.
A lot of good questions out there. Let's
Yes.
We talk a lot in class, at least, about the role of media and also of law enforcement playing with the idea of privacy. And can you guys just speak about your ideas of just how courts can start to begin to set up jurisdiction of how these parties, such as the media or as law enforcement, where it becomes invasion of privacy or protecting the rights and the values of citizens, or the idea of invasion of privacy, or just the right for the public to know, the roles of how that's differing and how maybe courts can begin to set up that sense.
If I just one thing I'll say very quickly is you kind of touched on two things there. You touched on the concept of torts, this concept of can we protect our privacy in other ways? So we're sitting here talking about the government and private industry, but are some of these lawsuits, is that the invasion of privacy, which, Judge, you were referring to? The other thing is this concept of the First Amendment, which we've spent a lot of time talking about the Fourth Amendment, but Will, your point is very well taken, is that when we have this amazing collection of data, the mosaic theory that Cannon or Janet, I'm not sure which one of you referenced it, where the government can know where we are at all times, it has a very significant chilling effect on our freedoms of association and our freedom of speech, which is the First Amendment. So in terms of the media and responding to that, what can be done is that's part of this consideration, and it's really sort of a topic we haven't turned to, but it is something that is an integral part of figuring out how media and privacy experts, how the folks in Congress can address that. And clearly that is a sort of subtenet of these Supreme Court decisions, that recognizing the chilling effects and the First Amendment implications, not just the Fourth Amendment implications. Does anybody?
I mean, I'll say one thing, and this is, again, perhaps more from a First Amendment perspective than a Fourth Amendment perspective. I've been traveling a lot this week, which means sitting in airports, captively listening to CNN, and so listening to a lot of the coverage of the Petraeus scandal. And I think one of the things that really struck me was that even in this age of tremendous cuts in the mainstream media, when you have a scandal or a controversy like this, it doesn't take people very long to scour all the publicly available information. And so, a day after the Petraeus scandal broke, people had watched every YouTube clip involving this Paula Broadwell, the biographer, and they had picked up on all of these comments that might, with the benefit of hindsight, have suggested what was going on. And it's very easy, again, even for somebody who before this scandal broke was probably not someone you would think of as a public figure. I mean, no one had probably heard of Paula Broadwell unless they had read the biography. And yet, overnight, the person turns into essentially a public figure. They're entitled to very little by way of First Amendment protection. It would be essentially impossible for someone in that position to bring suit claiming that their privacy had been violated, and even if they did, they wouldn't be able to obtain relief from anything resembling a mainstream media organization. So, I think it's just striking. Now, some might say that the response to that should be to come up with ways of providing heightened protection. California has a pretty muscular tort of a violation of your right to publicity, which has a little bit of a kind of privacy overlay to it. But by and large, I think there is very little by way of independent protection in the law. And so we talk about the Fourth Amendment because the Fourth Amendment is concerned about a very particular type of intrusion. It's concerned about government intrusion. And as Professor Fishman indicated, in a lot of these contexts we've been discussing, the information is in the hands of a third party already. And so the real question is, when the government tries to get that information from a third party, is the analysis different, and is there something about that disclosure that perhaps lessens the protection still further if it's the government that ultimately wants to get the information?
It's hard to sit here and be anything but pessimistic about privacy in America. Anyone who's been a criminal defense or prosecutorial practitioner knows that the ugliest of the ugliest cases never go to an appellate court, because if there's problems, they're pled out, or a deal or dismissal that the defendant can't refuse or take the risks. So the really sexy cases don't seem to go up on appeal. And I was thinking to myself that invasion of privacy in civil cases is probably going to be the best way to flush this out judicially, but I think Judge Murphy hit the nail on the head. There's no damages. And if there are no damages and there is no anything more than nominal, the plaintiff's lawyers aren't going to jump on these cases. And I think the only solution is the legislature needs to step in, be offended, and do something that's going to have some teeth. One of the interesting things that the legislature has done in the last decade is HIPAA, and HIPAA is the most toothless piece of legislation that ever existed. It costs the government, it costs hospitals billions of dollars to comply, but there has not been one civil judgment for a violation of HIPAA in the history of this country that I'm aware of, or at least was aware of 6 months ago after some research. So I guess I ask you collectively, pessimistically, what's going to happen to get this engine rolling?
Well, it's interesting that you mentioned HIPAA, because you're so right that there are a lot of problems, and it doesn't seem to protect as well as it should, and it costs everybody a lot of money to comply with the provisions and so forth. But there was a case in Maryland, and I wish I could think of the name of it, that predated the HIPAA statute and the Maryland statutes. It was a malpractice case. A doctor testified as an expert witness for the plaintiff, and the doctor testified that the defendant surgeon had performed a surgery that never should have been performed. Just shouldn't have been done that way. The defense attorney takes out a file that contains a hospital record of a different patient who wasn't a party to this case, but who the who the plaintiff's expert had operated on. And he cross-examines this expert to show that the expert who just said the defendant should never have performed this operation had actually performed the very same operation on another individual. So the plaintiff's lawyer, after he lost the case, goes to the other individual and says, do you know what they did? They went down to this hospital and they got your file out, and you were mentioned in this trial, and now everybody knows that you had this operation. So the person says, well, I want you to sue them for that. And there was litigation. So, I mean, here we go from a situation where this is open season. Somebody can just go down and get a hospital record and stick it into court, and then, followed by the HIPAA. So there may be an analogy here. We've identified situations, or I haven't, the panelists have identified situations in which there have been captures under these new and ever-advancing techniques of personal information that many people probably don't know has been accomplished, although some may know it and some may say, what's the problem? So now that we've identified this potential problem, we go forward to see if we can solve it legislatively in a much more effective way than the problems that led to HIPAA were solved. And ladies and gentlemen, you are the ones that will be doing this, because when you get out of school, you'll be at the forefront of this litigation, and we look for you to give us the solutions.
I just want to say one quick thing, though, in terms of the invasion of privacy actions, and is there any teeth in those actions? Is there really any money for civil litigators? Because let's face it, that's what it's all about. Plaintiffs' lawyers don't want to take cases if they can't make money. And so the judge was saying, like, what's the real damage? So they knew where I was in the mall. Actually, there is a really significant and amazingly growing industry and class actions right now about this based on consumer protection statutes. And depending on how every state has wildly varying consumer protection statutes. And every state's consumer protection statutes, depending on how they're worded, many of them often are violated when someone collects data in certain ways. And because the statute is written that you get a tag or you get an award for each time it's violated, that means each time someone collects this data, and they've done so in a way that violates the consumer protection statute, there's whether it's a $1,500 violation or a $150 violation, each time it's happening, it's there. And if you put a group of people together like that in a class action, you are suddenly talking about millions and billions of dollars. So I actually do have hope that there will be litigation about this, because those plaintiffs' attorneys want that money.
Yeah, and in some of the consumer protection actions, the statute provides for counsel fees.
Correct.
Regardless of the size of the award.
Even more incentive.
Tom, how are we doing for time?
I think
Okay,
we are, and
good.
I should at this point thank these panelists for their participation. Thank Ann for putting this thing together and for asking me to participate. Thank the school for getting this together. And thank the people who came to listen and to ask questions. Thank you all.
Thank you.